Sorry. Before we get started?
The red button in the corner, so it looks clear.
I'm going to say that it has. So I'll hand over to the chair, Councillor Anna.
Thank you. Good evening, everyone, and welcome to this evening's licensing committee meeting. My name is Councillor Anna Abela, and I am the chair of this committee. I'll remind everyone that this meeting is being filmed by the council for live or subsequent. Are there any apologies?
There are apologies. Apologies from absence have been received from Councillor Mokbole Gunes, Councillor Resh Rice, and Councillor Nicola Bond.
Thank you. Shall we do a quick round of introductions so that anyone who is watching this will know who is present? So I'll start from you, Naz, and we'll work our way around the table.
Yeah, I'm Nazia Chowdhury. I'm from Democratic Services, and I'm clerk to this committee.
Councillor Adam Small.
Councillor Bushika Omin. Councillor Sheila Peacock. Representing South Tottenham Ward as well.
And Councillor Ellen Weston.
Councillor Nick Da Costa.
Councillor Mark Blake.
Thank you. And Dahlia, would you like to introduce yourself?
Good evening, I'm Dale Barrett, Licensing Team Leader.
Thank you. Are there any items of urgent business?
No. Okay.
And any declarations of interest from the committee? Yes.
Just my usual one that I am a trustee of Alexandra Palace and chair of Alexandra Palace Trading Limited.
Thank you. So are there any deputations, petitions, presentations or questions?
None presented, Chair.
So we have in our pack the minutes of the meeting from 6 January. Are there any comments on the meeting, on the minutes? In that case, I think we can confirm these minutes. The first substantive item on the agenda is the consultation on the draft statement of licensing policy. We've received a report on this from the licensing team leader, so I'll hand over to Ms. Barrett to present her report.
Thank you, Chair. So we are coming up to that time again when we need to ensure that we take a look at the existing statement of licensing policy and make any changes that are required and ensure that we go through the process to consult on the revised policy and ensure that we have a policy in place by the end of January 2026. So we're just at the beginning of that process here. The panel has before them the revised document with track changes available for you to see within it. We are required under Section 5 of the Act to ensure that we prepare, consult and publish a statement of licensing policy every 5 years. And we are required to keep that keep the policy under review. In terms of recommendation, the report recommends that the committee approve the consultation on the draft of the licensing policy for 2026 to 2031. Note and agree the arrangements for the public consultation as set out within the report at Section 6. And note that following the consultation, the responses will be brought back to the licensing subcommittee, who will then make recommendations to full council for adoption. As I've stated, the reasons for the report before you is that the licensing committee is required to give the go-ahead for the consultation to take place. The policy itself looks to cover and demonstrate how the expectations really for the 4 licensing objectives and really sets out the council stall as to how we would want licensed operators to manage licensed activities responsibly in the borough. It's Section 5.9. I can give you just a summary of the main amendments that's been made to the document so far. So I have removed all reference to the coronavirus. The alcohol harm data has been updated, and just to stress that it's there as part of the background information around Haringey and the look and feel of Haringey, really. And that data is also contains things from the corporate policy and from the state of the borough document as well. I've updated the wording around payment licensing because this was the levelling up regulations became law in 2023 and impacted on payment licensing. So I've just reflected that. We have revised wording, as I said, from the corporate plan with links to various other strategies, including risk and harm to women and vulnerable in the late night economy. There's a wider bit around violence against women and girls in, when it comes to licensed premises and so forth as well. We have responded to the proposed Martin's Law by outlining what's going to be required for Martin's Law in terms of events and large venues, the safety and risk assessments, and dispersal of patrons from premises also. There is further reference to areas of the borough that are being blighted by street drinking concerns, and set out some expectations there about prospective businesses coming into an area, and thoughts around geography and the location, and addressing, how they're going to not add to these issues in those relevant areas. There's updated wording around the framework hours. The framework hours remain the same. We're talking about 11:30 or midnight, depending on what type of business it is. And, the expectation is that if you're wanting to go later, then come forward with a very robust plan, a very robust operating schedule to give yourself a chance to have a favorable outcome there. There's a new section on responsible management for licensed premises relating to match and event days in a given area. I say the given area, it really is around Tottenham, considering that the stadium has now increased its amount of events that can be held across the calendar year. And it's really thinking about mitigation as to the impact that has on the community in general. There are some examples of model conditions. They are there as a guide, really, for prospective applicants, but obviously they've got to tailor fit their operating schedule to suit their business needs, really. And the responsible authorities information has also been updated. So the policy sets out the council standards and that operators are expected to achieve and address issues that licensable activities may cause in relation to location, the location of the premises, the hours of the operation, and so forth. Chair, I'm mindful that the committee has read through. Just to pick up on Martin's Law, the overview. So Martin's Law, named after a victim of the Manchester Arena bombings, is a bill that requires those responsible for publicly accessible venues in the UK to take steps to reduce the threat of terrorist attack. It places a statutory duty on premises and events to implement reasonable, practicable public protection procedures and measures. I'm mentioning cumulative impact policy in so much as when I was preparing this to review the document, I did some consultation with public health and the police and some of the other RAs, and also did a quick survey on using Commonplace, which yielded back quite positive comments back from the public. To be honest, they felt that the offer of licensed premises in Haringey was pitched just right. They thought it was a good mix of premises in the borough. Some wanted to see some later hours. Didn't think Haringey had much of a nightlife as such, but all seemed to be one of the issues that was the main thread coming through was around off licenses and the amount of off licenses there are. And this was certainly borne through by comments that were fed back by public health and the police. Both parties are of the view that there is or a case can be made for a community of impact policy to be declared in the area around Spurs Stadium and also along parts of West Green Road. I have said that, the committee will be happy to listen to those arguments, but we can't do it at this point in terms of this revision of the current policy because time would not allow. So we're going to go ahead and go through the process to adopt this policy, so to make sure that we are, on the right side of the law and have a valid policy in place. And if public health and the police want to work in the background to look at gathering their evidence to show that there is a need for a cumulative impact in those chosen areas, then it can be a matter that we can pick up again in 2026, basically, and bring back to the committee for discussion at that point. And of course, we can always therefore start on, it's a very long-winded process to bring in a cumulative impact policy. And, if the panel are convinced that that's what's required, then we can certainly move forward with that after January 2026. Okay. I have set out at section 6 the various strategic outcomes that the policy does cross over with, and at 7.6 you've got the consultation timelines. So if I can just specify, so we've had discussions with the lead member already. She's been updated as to the changes that have been made and that the consultation will be underway. Once licensing committee agree to the consultation being done, the policy document will also be taken to the overview and scrutiny committee. And once we get back, and then the public consultation will be underway, and it's going to be it's going to be available on the website. There will be some comms around it also, and also dealing with our business and trade associations and so forth, as well as residents associations and licensed premises. It will be a 6 weeks consultation, at the end of which we'll gather in all the responses and do a further report that will come back to this committee with an ask that the matter is, therefore, any changes that need to be made will be made, and with an ask that it's then agreed to be taken forward to full council for adoption. Within the document, you've got there the finance comments, which is saying that the consultation exercise will be conducted online and therefore at a minimum cost. Legal have put in their comment also at section 10. And you also have within the bundle the equalities, the equalities document, which was also screened by the equalities team at Chair. Chair, if you have any questions, or if the panel has any questions for me, please.
Thank you, Ms. Barrett, for the presentation, and thank you for taking this piece of work forward. So I'm going to take questions from the committee first, and then I have a few questions myself, Ms. Barrett. Who would like to go first? So I'll take Councillor Cunningham first, and then Councillor Da Costa.
Hi, Dahlia.
Oh,
Hi. Just a couple of things. Yeah, thanks for explaining Martin's Law. That then triggered in when you went through that. So thanks for that. That was going to be a question, but you've answered that. Just on the section on the harms around children, there's no mention in terms of fast food outlets, vape shops. I just wondered where they come into play in terms of our thinking and our licensing requirements, looking at those in terms of public health harms for children. Thanks.
right. So fast food outlets won't really come across our board, our desk, to be honest, unless they are going to be operating after 11 o'clock at night and offering hot food and hot drink. They require a license, and I suppose they also therefore step into the realm of the whole delivery considerations and prevention of public nuisance, that sort of thing. But in terms of fast food, as in terms of public health and the healthiness of that food, that really is a public health issue. And I know they've worked with the commercial environment health team to do some work with businesses around making, how they cook and prepare food more healthier. And with vapes, again, that doesn't really come under the licensing process as such. However, it's the trading standards team do pick up and deal with the enforcement of vapes, and I think they were talking about new legislation coming in around tobacco and so forth. But obviously, if a licensed premises, an off license, is found to be selling vapes to underage or stocking illicit vapes or illicit tobacco, then more often than not, you will find the trading standards officers will submit a review under the Licensing Act to show that, because obviously it's crime and disorder, and they're still required to do to take reasonable measures to ensure that they are doing all they can to prevent crime and disorder taking place on their shop. And so you may find reviews come through that are to deal with illicit goods in that way taking place on a premises that has an alcohol license.
Thank you.
Thank you, Ms. Barrett. Councillor Da Costa?
Thank you, and thank you, Dahlia. The government yesterday announced that it's creating a new national framework on licensing, which will supposedly cut red tape and allow agent of change principles. So my question is, if we go ahead with this, which we have to, because we have to do every 5 years, and gets approved by full council, do you think we would have to then do an updated new version of this once those rules come through? So we potentially in a year to 2 year, we'll be having to do this again based on what the government's announced.
I feel that would be the case, to be honest, and I fully expect to have to do another revision as soon as we have further clarity on Martin's Law as well, in particular around how Martin's Law is going to impact on safety advisory groups that look at large events and that sort of thing. So yeah, fully expect to have to do some interim revisions. There seems to be lots happening to make changes to the Licensing Act.
And can I just get it? Sorry, can I get a clarification? So then, if you have to make revisions based on this new national framework and Martin's Law, do you have to go through the whole process, including consultation again?
Yes,
Okay.
we will do. Yes, we will do. Yeah.
Thank you.
Thank you, Councillor Da Costa. Councillor Small?
Thank you, Dahlia. Can I just, sorry if I misunderstood about the cumulative impact policy. Is it right that it's not possible to have a sort of template cumulative impact policy where we say these are the sort of premise, this is the approach we would take, these are the thoughts we would approach it with, rather than have to lead on a sort of data specific location based cumulative impact policy? There's no opportunity to deal with that problem now rather than come back to it in 26.
Right. So you can even now consider the cumulative impact of premises in a given location. If something comes before you, certainly can do that. What the police and the public health are actually wanting, though, is to have a area defined that says that we believe that location is at saturation levels for off licenses, and we don't want to have any new off licenses coming into that given location.
Yeah.
And the existing off licenses, if they try to go for later hours and that sort of thing, there is a presumption of refusal to them unless they can show that they're not going to add to the issues that are already taking place in that location. But there's nothing stopping the licensing subcommittee. If you've got a case before you that is in a location that is a cause that you're thinking, what's the, if you're asking officers, can you let me know what the what complaints have taken place in that location with other businesses around and that sort of, you can certainly do that. You can certainly look at general cumulative issues on any application. Yeah.
Thank you, David. Can I ask one question, please? Thank you. Just on the consultation process itself, he's trying to make sure that it's as sort of public friendly as possible. I'm grateful for you and the team for doing the public survey beforehand because I think it's important. I know that the circular letter will be sent to the list as set out as 7.2. I'm cautious that we don't end up in a situation where those that are the sort of interested parties in this overwhelm the public who may be less aware of this happening. So it's more just a sort of general note of encouragement on that one, so that for whatever ways the council can encourage public involvement in the process, council that would be great.
Definitely, yes.
The specific question would just be on the consultation questionnaire, whether the amendments to the policy are balanced, fair and reasonable. If from a public point of view, I think it's ensuring that the public are informed as to what end these things are balanced, fair and reasonable, so that they know what the measures are that they should engage in. The part notes in that rather than like anything to take back. Thank you.
Okay, thank you. Thanks for feedback.
Thank you, councillor Small. Any other questions or comments? Councillor Amin?
I don't know whether it's kind of relevant to this document, David, but I'd really appreciate it if you could just think about it. I noticed with the Tottenham Hotspur major events this season, I had some complaints, actually, about issues to do with the events and how they're managed. So I just wondered about that. One is they found that people were vaping, so the whole place was full of people vaping continually, and I thought you couldn't vape, and she thought that vape in the building or during the concert itself. There's no action being taken. So I just wondered about mentioning something in that as part of the restriction for them to consider. And also you mentioned here, this is about, to prevent possession, for example, in matters of consideration. I mean, I know that they check bags, but they don't check clothing. It's a nightmare. I can imagine, I feel sorry for Tottenham Hotspur, but it's a nightmare because people, bags are checked, but actually clothes, jackets and coats are not checked. So I think some of the wording needs to be a little bit tighter, just to ensure that actually it works better in the way it should do. I wonder whether they do. Well, go outside.
We'll come to you, councillor.
I'm not just trying to think of anything else. I think those were the two things in relation.
Okay. No worries, councillor. So the vaping thing I will need to take a look at, because obviously there is the 50% rule, and there is, the stadium itself is open at the top. So they could be smoking there, to be honest. It's only if they're inside within the club rooms and within the building itself, really, that you would definitely not want to see anyone smoking. But the actual bowl itself has an open, it's an open top. But it's an interesting, I will raise that with Spurs. And in terms of searching, so obviously Spurs set in place their search regime, and depending on the type of event it is, there may be more intrusive searches carried out on some events than on others, to be honest. But it's an interesting point, and I will also take that back at the next safety advisory group meeting that we have.
Thank you. Thank you, Ms. Barrett. Any other questions or comments? In that case, I have a few points to raise myself. The first point is similar to Councillor Small, so it's on section 7.2 of your, which relates to the circular letter that is going to be sent to various individuals to that the consultation has been launched. And you mentioned that this will be sent to representatives of residents. I was wondering, what do you mean by representatives of residents? Does that mean councillors? Does that mean residents associations? And if it's resident associations, how have you chosen which associations to inform?
Right, so we use the consultation team, who will do quite a, they will just send out the links to all the resident associations that they've got listed. Yeah, we will also go via the economic development team, who will share the consultation link also with the various traders associations as well. And we blind copy in the residents that have been in contact with us. So there's a few emails that go out like that, where we just send out in batches to residents that have been in touch with us, either made representation, that sort of thing. Yeah, and any residents association that have had direct contact with us as well. So hopefully that way we manage to capture everybody.
Anna, can you ask us what the languages that consultation is in?
I can hand over to you, Councillor Peacock, and you can ask that question yourself if you like.
Well, it's just that what concerns me, as you know, I live in the area of Spurs, and there's hardly any English people in that area. There's every language you can think of in that area. And I'm just concerned about when you send out consultation, is it just in English? Because I've just been through a planning application in where I live in the road, and out of 100 houses in the road, there's only 2 people who are English. They're Somali, they're every language you can think of. And so the result of the consultation was zilch. There's only myself and the lady over the road that actually complained about it. So I just
I've got a question about which languages
yes,
the consultation is going to be.
because the area that you're consulting in really needs to reflect the residents in that area.
Right. Well, it is a borough-wide consultation, and what has happened in the past is that comms will always include a line that says that if you need a copy or to see this in the various language, and provide further links for people to be able to make that submission or to contact to have that done.
I would like to know the response that you've had from people actually reading that bit and asking, because I don't think that happens. I really don't.
I don't keep that
That's
information, Councillor.
No, but by putting that line in, it makes you feel better that you're consulting everybody. In the point of fact, they'll just put it to one side and throw it out. It's rubbish. They won't look at it and they won't ask for it. I promise you.
Okay, but yeah, so it's
Yeah.
the corporate response that will be put out at the bottom of all the other information.
Yes. I am consulting others in other departments about the same thing. Because if you're asking people to respond, you really need to do it in their language, or and just having a byline saying if you want it, that doesn't work. I promise you.
I think that's a piece of feedback we can share with
I will take that up with the consultation team, yes.
Councillor Weston.
Yeah, thanks, and thanks, Dahlia. My question is around, just to follow on the consultation. Given there are some significant parts of the policy that relate to children, is it possible for this to be sent out to schools and colleges in the borough as well? To the head teacher or whatever, so that they're highlighting that there are sections specifically relevant to children and young people. Because again, that might provide some useful feedback as part of the consultation process.
Yes, certainly can do, and happy to do so. It is sent to Children's Services, and I no doubt will be going to one of their team meetings to discuss the policy and if they've got any feedback on that. But yeah, happy to send it out to schools as well.
That'd be really helpful, I think, because Children's Services have got obviously an overview, but those schools will be dealing with the impact of licensed or unlicensed premises in their immediate local area, and it might be that it provides useful feedback on the policy, but also other information opens up lines of communication. So thanks.
Thank you.
Thank you, Ms. Barrett, and thank you, Councillor Weston. I have a few more questions. As I understand it, Section 3 of the updated licensing policy sets out what the council's expectations are from licence holders. Sort of a general observation that I have as having now chaired the licensing subcommittee for a few years is that we often encounter applicants or licensing holders who appear not to have a very high level of understanding of what the council's expectations from them are. And so I wonder how are we going to, once it has been adopted, publicize the updated licensing policy so that license holders or applicants know what is expected of them before they come before us? A hearing, and potentially one suggestion would be to, on an annual basis, hold public or aspiring license holders or more experienced license holders to update them and make sure they are aware of what the council expects from them.
Yeah, so we would love to do that, and we've done that in the past. However, budgets just won't allow for things like that now, I'm afraid. So yeah, we did used to do like an annual call in the license holders and have them in batches and talk with them and so forth, but not in the past couple of years, to be honest. So we do, it's a standard practice really. So when we get an applicant that comes to us, very rarely, unless it's a solicitor, very rarely do we get an application that we accept first time round. And so when we have to go back to them, one of the things we do ask them is, have you consulted the policy? Have you looked at whatever parts of the policy would be relevant to their application? And have you taken a look at the model conditions as well? And so we always provide the link to that. Yeah. And it is on the landing page also. It's not been moved, but it is on the landing page in terms of the licensing matters as well. So we do direct people to it as, as part of everyday business, to be honest with you. Yeah.
Thank you, Ms. Barrett. It's interesting to know that we used to have these types of public meetings and we're no longer organizing them, and it seems that the constraint is financial.
Yeah.
But I do wonder, because I can imagine that this is something we could organize at relatively low cost. We could do it here in George Meehan House, publicize it through the channels that you have, potentially emailing people who've contacted you and inviting them to a public meeting here. So potentially, I think this could be done without incurring significant cost, unless I'm missing.
Yeah. So it was the hire of the space, because obviously we were at that point where because the last time we did this was when the Civic Centre was in use. And even then to hire the space, there was a cost incurred for doing so for the day. We've subsequently worked with the police when they were rolling out the Arts for Angela scheme. They hired Alexandra Palace and invited up licensees in batches across a whole week, and we took part in that. So it has been done, but obviously with Arts for Angela, the police had a separate budget set aside in order to facilitate that. We do communicate regularly with license holders, so we have our email mail shot that is ready to go, just to be sending out information to licensed premises. It's something that we had to put in place over COVID, and we've just carried on with it and update it as and when, we add to it as and when we get new applications in and so forth. And we also rely on the Regen team. The Regen team runs the business newsletter, and again, we'll put articles in that as it does go out. And again, that business newsletter came about after the door-to-door work that was done during coronavirus times, engaging with licensed premises along each high street face-to-face and gathering those details. So yeah, we make use of all of that information that's been gathered to communicate with them.
Thank you. That's really helpful to know. And it's helpful to know that we were able to hold these meetings in the old Civic Centre, because hopefully once the Civic Centre has been refurbished, we will have a space to do this again. And I know Sheila and I both sit on that working group, so maybe this is something we can raise in that format.
Tottenham Green Leisure Centre has a really large facility, and that's ours now. And also an even larger facility is at the Water Farm in their community hall. It is really large.
So potentially there are a few venues that the council has at its disposal where we could hold this type of meeting. I have two more questions. I have one question on cumulative impact. So you mentioned that the police and the council's public health team are working on a cumulative impact policy specifically to address areas where the prevalence of off licenses is causing antisocial behavior. I was wondering, can this only be applied exclusively to off licenses or potentially other types of premises? And I'm thinking in particular of adult gaming centers. Would you be able to apply this to areas where there's a high concentration of adult gaming centers?
Okay, so under the alcohol licensing regime, the police and public health were only looking at the off licenses. There isn't currently an ability under the Gambling Act to be able to do cumulative impact. It's something that was mentioned in the white paper that the government had released at the time in 2022, I believe. But I'm not aware of it that being brought forward or being carried any further forward at this time.
That's very helpful to understand. So I have one final question on major events at Tottenham Hotspur Stadium and Finsbury Park. So in that section of the updated licensing policy, you set out the council's expectations for event holders. And I was wondering if you have considered the impact of vibrations from open air events in Finsbury Park homes. So I am the councillor for Haringey Ward, and we have sometimes observed with events in Finsbury Park that properties in the surrounding area have experienced vibrations due to people jumping, for example, in synchronicity at these events. And some of those event holders have commissioned experts to measure the vibrations in those to make sure that those vibrations are at safe levels.
Yeah.
Is that we could incorporate in the policy as an expectation, as something we would want event holders to do if there are reported vibrations in neighbouring properties?
Right. I think the whole issue around vibrations is very much a minefield, really. The Finsbury Park issue, is not something I wouldn't be encouraging anyone to use the licensing process to deal with the vibrations issues at all. There is a underground that runs through that area. It's heavy traffic and so forth. I have been present at some of those meetings from, in particular, residents on the Hackney side who've come to those meetings and said, we are having problems with the overall landowners. We don't think they built this property right. And then in the next breath, they're saying, and we're suffering from the vibrations that's being caused because, 2 weekends a year, the park is being used for this. That's not something that they're going to be able to use the licensing legislation to get any outcome from. If it was about noise nuisance and they are, they're saying that they're being blasted out of their homes and it's directly in relation to the event, then yes, of course, they can, get together and do a review based on that. But in terms of vibrations, that would mean that homeowner or that occupant getting their own independent surveyor contractor to come in and take assessments and do readings and that sort of thing, independently of Festival Republic, really, or any other operator there, in order to show the causal effect of that. Yeah, and then of course I think the council would need to be taking a view. If that was the case, the council would be needing to take a view as to the use of the land.
Thank you, Ms. Barrett. Are there any other questions or comments on this agenda item? if there are no further questions, if we are all in agreement, I think we can agree to launch the public consultation.
Agreed.
Excellent, and thank you, Ms. Barrett, for this piece of work. So I'll move on to the next agenda item. I admit, as a consumer of some of these services, very close to my heart, which is the revision of functions and fees under massage and special treatment, revision of conditions.
Last which treatment. Yeah.
Is that page 120?
Yes.
Yes, Ms. Barrett, please can you introduce your report?
Thank you, Chair. Well, apologies because this report is now coming to you because I have to say I messed up when the actual initial fees and charges came to you in January. And it was only after that report had gone, legal then said, you didn't actually mention special treatment clearly enough to make clear that you were doing the 5% increase on those fees. So you'll need to take a separate report back to the licensing committee. So this is what we have before you this evening. And I thought, well, as I was doing that, I looked at our list of the conditions that are already in place, and they were from 2010. And the council is part of what was a pan-London group that looks at the various treatments that are being offered under this legislation and has a working group on Knowledge Hub that pulls together standard conditions. So I thought, well, might as well just lift those standard conditions and update our ones with those. They're the same conditions, but just updated, basically. So panel has before them, this report is looking at the 5% increase in fees and charges, which is a requirement for the fees, and it's all right to do it at this point because the new fees will come into effect in time for the renewal of the existing MST licenses, which happen by the end of September this year. The report also looks at the revised and updated standard conditions that are applied across the board for licensed premises, licensed special treatment premises. In terms of recommendations, the committee is asked to note the contents of the report and the appendices, approve the changes to the massage and special treatment licensing process set out in section 4, exercise its power under section 10 of the Act by regulation to prescribe the revised standard conditions for special treatment and to approve the fees and charges for this function also. The London Local Authorities Act 1991 is a discretionary powers, and it allows us to put in place conditions to govern how special treatment premises that offer various beauty treatments, massage, manicure, acupuncture, tattooing, cosmetic piercing, but I hasten to add things like ear piercing. Okay, we don't go into the more the deeper kind of piercings and various other, to call them mutilations, that's done really, because obviously people do go in and get their tongue split and all that sort of thing. So we don't license that far. We don't deal with that. Chiropody, light treatments, electrical treatments, and other similar treatments that are carried out and in scope of the Act. I should hasten to add also, this legislation does not deal with the aesthetic stuff. So we don't deal with Botox and injectables and fillers and all that sort of thing. We've been waiting now for the past couple of years for new legislation to be brought in to deal with that, and we are still waiting for that. That's not to say, I should say, we don't license it, but the health and safety team under the Commercial Environment Health team can deal and do deal with premises that don't operate those kinds of premises in the right and proper way. Just to run through. So we have looked at the processes that's in place And at section 4.4 of the report, you have there, we just set out the application requirements and who we consult with as well. Just to give an overview really of what's involved and so forth. In particular, we are now asking for like is it DBI? That's right. But to do checks on individuals as well. The police will also do that. So the declaration of convictions really, so that, you know, we can do background checks on people that are really being put in a place of trust really to carry out treatments, laying on of hands on other individuals as their day-to-day work. We have noticed in recent years for MST practitioners, there is a move towards exemptions and them applying to various affiliated bodies to be exempted from having to apply for the license with the local authority. It's a growing trend. We've got quite a few premises now that will do that, and ones that will also declare that all treatments are being operated by or being carried out by a doctor or under a doctor's supervision, and so therefore things like massage, obviously if it's a nail technician, of course they need to be licensed, but we have had one or two people premises who are offered various massage who say that's done under the doctor's guidance and so therefore is exempt.
Mm.
Okay. So we've revised the conditions, but to be honest, the conditions look at ensuring that, you know, your suntanning kind of a business is always manned. You know, we don't want to have anybody, you know, being locked in a you know, standing suntanning booth and not being able to release the catch on that and that sort of thing, but there is quite a growing voice of new types of businesses that are coming through that want to be able to operate unmanned tanning salons. And we have been saying no, and we'll carry on saying no in the borough because it's not safe to do so. We've also had a death in a salon, in a sauna. And an elderly gentleman who passed out and ended up dying in the sauna. Again, if somebody was there to go and check, but because it was part of a gym, you know, they were able to use that without anyone really going to check on that individual. So that person was found dead in the salon. So again, that led to an investigation, and turns out that the lock on the door wasn't working, it was malfunctioning and that sort of thing. So again, that had to be put right. We are, just to cover off the fees, we are increasing it by 5%. It's what the other fees that in the report that you had before you in January was also setting out as well. So standard 5% increase this year as advised by the finance team. And you do have in the document at Appendix 2, I believe, on page 122, what the new charges are going to be with the 5% increase. And at Appendix 3, you have got there some proposed additional fees that we're looking to bring in, which is around the exempt practitioner fees and just the exempt premises registration, really, and for change of details as well. Again, that's another point where we lose out as a council because existing businesses will want to make changes and they wait until the need to renew comes up and to do that, so that they only pay the one fee and won't do it any other time of the year. So yeah, we're trying to do some kind of a process changing there as well to allow for that to be considered. Okay. I think I can leave it there. If you have any questions for me, please.
Thank you, Ms. Barrett, for your presentation. You've preempted one of my questions, which was indeed about whether injectables are covered by this policy, but I have a few other questions for you. But first, I'll open the floor to the committee. Councillor Peacock, then I'll come to Councillor Weston and Councillor Da Costa.
Dahlia, lots of jewellers advertise ear piercing when they sell earrings, and are they licensed?
They
And
should be, councillor. That's the answer to that. They should be. It's something that we have asked the ASB enforcement team to do a bit of work on. Yeah, to go and do door-to-door visits at these premises to find, to see exactly what they are doing, what they're offering.
okay. My other question is about the fees. I go regularly to a nail bar, and I have not ears or nose piercing, but I have a manicure and a pedicure on a week. And I did not know that all the people that do that have also to pay an amount of money. So I'm just wondering, the owner of the shop, does he pay the 197? And
Yes.
each person that works for them has to pay 112. And
Yes.
how do you actually get that money from them?
They- Right.
Because in lots of barber shops and hairdressing shops, you get the people who buy like they work on one chair. So it might be that that person is the person under the applicant fee, or is the person in the other one? I don't know how it works. There must be about 7 or 8 different people working in the place where I go. It's extremely busy. And I just wondered, does the owner pay the money, or does each person, do they
Yeah.
set, like they license a chair? I don't know how it works.
Right, okay. So you'll find really for the nail shops that the owner is going to pay the full fee because it's their business at the end of the day and people are working in their business. We have situations where we have a person who rents a room, let's say, in a hairdresser's, and that person who's renting the room rents that room to be able to offer massage or special treatment. But that individual will pay their own fee. Yeah. So
When I have nails done, will that person have to do that as well?
yes,
the-
they do. Yeah.
And,
So the
and
manager will
and who-
pay the overall fee for everybody. It pays for the application and for each nail technician that they have working on site.
so he has to pay £112 for each person. There might be 8 people working there. And so who chases that to make sure that he has the right, is paying the
we-
right amount for the amount of people working there?
Right. So we will, they fill out the form and provide the certificates and details of each therapist. And the environmental health officer then goes out and does the checks and makes sure that ventilation is good on the premises, that the certificates that have been handed in are for the right people, correspond with the right people that are going to be on the premises, and that things are above board.
Well, I've got no complaints, I promise you, because I wouldn't go back on a regular basis. But I'm just intrigued to know about the money.
Yeah, so they have to pay, the fee has to get paid at the time when the application is submitted.
Thank you, Ms. Barrett. Councillor Weston?
Thank you, Chair. I've got a couple of questions. So first on the Appendix 2 around different classifications. What are they based on, David? Because it strikes me as a bit strange. Because if they're based on harm, so by what are they based on? I mean, who determines what's in which class? Because it seems strange to me that if class 1 is the class of treatment that is most likely to put the public at risk of harm, which I can understand, tattooing, etc. Why isn't liposuction in there, for example? Because I mean, that's invasive and potentially extremely dangerous. So what's the basis for the classification?
That's only a partial list there, councillor. There's actually a full A to Z of the treatments with whichever class they belong to. I've just done a snapshot there of.
No, sure. But my question is what's the basis? Like, how do we determine which treatment is in which class?
So the more intrusive treatments, like you say, anything that's piercing the skin, is in a class 1, and your lower treatment, so nails, for instance, is in class 4, but I believe that there is an argument to actually put that in a class 3, in fact, because that can also be quite intrusive and people have ended up with infections and stuff, you know.
Oh, yeah. So,
Yeah.
so then if it's about piercing the skin, then a lot of things that are currently on the snapshot of class 2 should be in class 1. Because liposuction will pierce the skin, mole removal will pierce the skin, thread vein treatment, you know, etc. There's a lot there. So can we review that to make sure that everything that should be in class 1 is in fact in class 1?
Yes, I can do. I can take a look at that.
Thank you. And then my second questions are on the process in.
Before you come in, can I
Sorry.
get in on
Yeah,
the class, the classes? Because I was actually planning to ask about this as well, and you've actually preempted one of my points, Dahlia. I was quite surprised to see manicure and pedicure in class 4.
Yeah.
Essentially, poor sterilization and poor hygiene practices in those types of salons can lead to the transmission of various infections, including
Absolutely.
and I am quite concerned about the extent of compliance across the borough with the hygiene standards that are required. So I do wonder whether we need to either look at the classifications again, or potentially clarify that just because a treatment is in class 4, that does not mean that there isn't risk of the transmission of infection. And related to this, you made the point yourself of manicures and pedicures can be quite invasive.
Mm-hmm.
There's a blood spillage protocol, I think, for the class 1 treatments, but I don't see that in Appendix F for manicures and pedicures. And I think that's where some of the serious infections may arise. So I wonder if we do need to add that protocol.
I can certainly take a look at that. Yes. Yeah.
Thank you. Back to Lois.
Right, so on page 117, so this is around the proposed application processes. So when a premises is looking to renew or vary or transfer the license, then obviously, you know, the requirements are lesser than for a new premises application. Obviously, I understand that. My question is there or should there be a point at which the original license is old, and therefore actually we would want to say, even though you're renewing, now we want to see this documentation again, just for our own comfort, because, you know, say you've had a business for 10 years, 15 years, there can be enormous changes. We've got no guarantee that that business has got proper insurance or anything else. So can we do that? Just say, like, you won't have to pay anymore, but after a certain period of time, your renewal will require that you provide us with this updated documentation so that we've got something up to date sort of on record.
Yeah, so every year when they renew, they do need to show us their public liability insurance. The only thing really that may miss a year or may not be required for 3 or 4 years is the electrical certificates that they give to us. So
Right.
sometimes the PAT testing, if it's new, if they've got new equipment in there, then yes, they've got to provide the PAT testing for that new equipment. But if it's like the general electricity certification, the NICC, that's a 5-year thing. So, you know, when they come back, if they serve that on us the first year, when they come back the next year, we're not going to ask them for that because we've already got that on file. But their public liability, and if they say that they have any affiliation to an exempted body, we always check on those things and ask to see that.
And so would that also be the case for like the fire risk assessment, local rules document? So as a matter of routine, so can that just be reflected then in that table around the process for renewing? Because at the moment, that looks like you provide all this stuff the first time you apply, but then not after that. And it might be much more detailed in the policy, I'm sure, but I think it would be helpful on any table that the public's going to scan through for that to be clear. And my final question, which is more general, is are the licensing teams, the officers who would go out, and the health and safety teams and so on, like, could you just give us a bit of comfort around the extent to which they're trained in sort of recognising modern slavery or the risk of modern slavery? Because I'm aware that these industries can sometimes be linked to that particular risk.
That's true. So to be honest, that is really dealt with. We have a couple of things. So when operations are being done throughout the year, the commercial environment health team are contacted and will work in unison with the police team that are doing these, or we get on a monthly basis, we get the immigration home office team contact us, alert us to which businesses they're wanting to go to. We provide the documents for that business, what we hold for them, and then they will go in and carry out the visits and to deal with exactly that, really looking for modern day slavery. Sometimes they are accompanied by the police licensing team as well. I believe there's a little bit of an issue around officers working with the immigration team, but you know, we at least accommodate and give whatever information we hold and provide contact details of businesses as well. And I suppose on the other side of that is we've had a couple complaints of inappropriate touching, that sort of thing. And again, those kind of complaints are investigated by myself and the police licensing team.
Thanks. So just to come back on that, to be clear, I'm not talking about what might be sometimes described as illegal immigration. I'm talking about, are our officers, the council's officers, trained in recognising what are safeguarding risks arising from modern slavery in these kinds of settings?
Yes, they are. The commercial environment health officers that go out and do that, yes, they are.
Thank you, Ms. Barrett. Councillor Da Costa?
Yeah, no, so well, first I was going to follow up on that point. I think you've covered that about modern slavery, because I have to do various modern slavery audits with work. So it's just important that officers are aware what they're looking for. I've got some questions on page 122, the current proposed fee structure, and specifically class 2, osteopathy and chiropractic are both listed there, but they're both exempt under the Act. So therefore they wouldn't be subject to fees, would they?
No, they wouldn't be subject, but we are seeing a number of, can I put this, therapists that have had like a standard qualification coming through to say, I want to be able to offer these kinds of treatments. This is my NVQ level 4 or whatever that says I can do it. And so that's why it's been included in that way. But normally we would expect for the person that's doing it, if they are GMC registered, then they wouldn't even come to us at all, to be honest.
Yeah, so if they were registered with, for example, so the two bodies for those organisations, the General Osteopathy Council and the General Chiropractic Council, I believe, members of those, then they wouldn't be subject to this. But this just covers those that claim to be a chiropractor because they pulled someone's leg at one point and then say they're a chiropractor. Okay, fine. Thank you. Just want to double check we're not penalising people who are valid chiropractors and in breach of the Act. Okay, thank you.
Thank you, Councillor Da Costa. Councillor Small?
Thanks, Chair. Thanks, Delia. The same on the page 122, the appendix 2, just to note that NV1 said where it says the maximum basic applicant's fee, I think still has the pre 5% rise at 660.
Okay. Thank you.
698, just wondering. And on that same theme, just to clarify, these we may have misunderstood. It says earlier on at point 8.5 that the council can approve an MSc license for any period not exceeding 18 months before having to be renewed. Then the fee structure mentions an annual license.
Yeah.
So this is something they have to do every year. 12
Yes,
months.
that's right. Yes, yeah. Harrogate's already set it at a yearly license previously, so I've not brought that to the table this evening because we're not looking to change that.
Thank you. Then just on question 4, why do we refund people if they don't use up the whole year? Do we legally have to?
Yeah, it's in the act that yes. So we had already said, and it's worked out on a pro rata basis.
Yeah.
So we find that, yeah, we do get businesses that are closing down and so forth. If they're not, they will put in for their refund of whatever part of the fee. And the same thing happens under, because it's a discretionary power, isn't it? So we find the same thing happens with that and with our special street trading people as well.
And is the £285 that can be retained by the council to cover the fees and so on, is that per applicant or per additional person, or that's just the entire licence
It will
itself?
be per application.
Thank you, Ms. Barrett. Any other questions from the committee? I just have two final questions. So the first is that in the pack, there's a process for residents to object to a beauty parlour license when this is applied for and set out in quite a lot of detail. I was wondering if a resident goes to a beauty parlour, a salon that already has a license, and they notice that the conditions aren't being complied with.
Yeah.
Who can they resort to? Who can they flag this to ensure that the license is reviewed?
Okay, so they can come through to the licensing team, but inevitably the people that go out and do the investigation will be the commercial environmental health officers.
So who should a resident contact? Would it be the
I would
license?
prefer they come through to the licensing team, because then we need to engage with the business in the first instance. And it's then referred on to the commercial environmental health officer, who will then go out on our request, basically, to go and engage face to face with the business.
Thank you. That's very helpful to know. And then I have a final question on the list of special treatments.
Mm-hmm.
You might be aware that I think it's been a couple of years now that the former supermodel Linda Evangelista had reported that her body had been permanently changed in a way that she did not like because of the cool sculpting treatment. And I've actually seen this being advertised in salons in our borough.
Sorry,
So
what treatment?
It's called cool sculpting. And basically, as I understand it, it's a process where fat cells are frozen.
Right.
And when it goes wrong, is these fat cells freeze and become solid in your body, and you can end up with solid lumps in your body. And there have been some high-profile cases in the press where this treatment has gone wrong. And the reason I raise it is that walking around the bar, I've seen salons advertising this, and I wonder if they are doing it safely and if residents are aware of the risks. And so I wonder if this is a treatment that's on your radar, and if this is something you can set conditions for through this policy.
Okay, I will need to look into that, because I'm not sure that it's actually a licensable one. Yeah, leave that one with me, please, and I will.
But there's no piercing of
No,
the
but as in,
skin, yeah.
it's not covered, yeah.
Yeah, no, that could be the case, but I was just wondering, because I've seen as in salons, borough.
Right, okay. Yeah. So some of the stuff that it is offered, the hard and fast rule is that if it's not a laying on of hands directly, then it's possibly not going to be licensed. But leave it with me. Let me look into it, and I can send you an email afterwards to let you know.
That's great to hear. Councillor Amin?
Yeah, I was just going to ask about how would you know if they haven't renewed their license, for example? I had a couple of questions actually. Renewing their license was one, and how would you know that they've not renewed and they've renewed it correctly? They haven't, missed the number of staff they have or whatever. How often do you check that businesses are complying with license? I mean, that's one.
Okay.
Two, you go to restaurants and places, you know what the quality of the food is going to be like. There's a food standards thing up. And there's a way, people know how to complain about poor quality food. But I just wondered whether we again need to have some sort of approach to ensuring that it's a place where people can complain about. You know, it's not easy. I mean, we were just asking about complaints and whether it goes to licensing or some other committee. I think to have a kind of information around how you complain about poor service would be a really good thing. It will improve safety, and it means that premises will think carefully about how they're delivering things. So I just wondered about that, and I wondered also whether we, in our magazine, you know, our own internal magazine, whether we could do a thing about licensing of premises of beauty salons and so forth. But you know, how you manage to be safe in these places, because actually it is quite risky, you know, it is quite risky, and you never know quite who you're going to get, whether that person has the expertise of it or they don't. And I've had my legs lasered for hair removal, and I wasn't particularly infrared, I have to say. So my experience is, I don't know whether they have qualifications. I don't know whether they have an understanding about your skin and the impact it has. So I just worry a little bit that it's left to, we're leaving them to their own devices in some ways, and to have a kind of campaign around increasing knowledge. And it particularly applies to women, but it applies to men as well. But I think, you know, increasing knowledge about what you do before you even go into one of these places and check qualifications, for example, just a kind of, you know, a bit more about thinking about how we protect our residents.
Yeah, okay, so, right, so your first question, how do we know if they've not licensed? We send out the applications a month and a half in advance to each of the registered businesses that we have. And provided they submit that application back before the expiry date of their existing license, they are able to continue operating on. The ones that don't submit back to us by then are added to the list for the ASBT to go and do doorstep visits on and to follow up with them. And that normally then means that they get an application form into us, really. You've raised a good point around how do we know, and how, you know, like a scores on the doors kind of a thing for these types of premises. Any reputable beauty salon, you know, doesn't want to have the negative publicity, really. There is Treatwell, which gives like an overview of good practice, or, you know, good reviews on premises. It really is difficult, and I agree with you. And I think this is one of the things that we are waiting to hear from government about, you know, what is the new landscape going to look like, because we do have a lot of these premises now that are offering the aesthetic works, and alongside your normal common garden, like, you know, beauty treatments. And yeah, it's like the Wild West at the moment, to be honest. And it really is potluck. I think it's quite challenging for anyone to be going into these salons now, to be having things done. And people do need to do their own research, and, you know, familiarize themselves with the kinds of treatments that they want to do. But we are fighting, I mean, you know, the beauty industry is costing it, there's a lot of money in that. You know, we've heard recent stories of a case in Brent where somebody went for a Brazilian butt lift and was quite prepared to go and get that done in a hotel by somebody. So, you know, you are fighting against people that obviously want to be able to get these things done and feel the need to get these things done, and are willing to take that risk, you know, to the point where it has ended up in people dying from the treatments that they put themselves through. But yeah, so we are awaiting the new legislation, which we're hoping will deal with some of those issues, and maybe bring about like a scores on the doors and best practice, you know, to the forefront. And Councillor Cool-Scumpton is aesthetic, so it's not covered by this legislation.
Thank you.
One final thing. I mean, when you when they get a license, are they supposed to put it on the door or somewhere in a way that everyone can see it's been licensed? Part of that, can we not put a thing about where you put your complaints? Because otherwise there isn't anywhere to go. I mean, I wouldn't know, seriously, I wouldn't know if that comes to you. And I think any other resident, if you, especially if you think, you know, you're vulnerable to pressure on something you want to look better at or whatever it is, that's pressure. You know, it's quite hard. People just do it and there's a lot of money on it. You know, I think to make sure that information is there would be a really helpful thing. So you have a license, but you also have the information at the bottom to say, and it needs to be displayed, that if you've got any complaints about the way you've been treated and your treatment you received, please complain to such and such a, because
Yeah.
otherwise, like, there's nowhere to go, especially if you're young or older, like my friend here, with pink nails. You know, it's just it's really quite worrying that, you know, that people haven't got anywhere to go.
Definitely, I'll take that forward, Cass, because I think it is something that we've thought about doing in terms of part of the responsible retailer scheme, to have something specific for. We did actually think about doing it for hairdressers and barbers and beauty salons as well. But yeah, it's about resourcing, so we've not taken it forward, but it's definitely been spoken about. Yes.
Thank you, Ms. Barrett. If there are no further questions or comments, we will conclude by adopting a motion that will resolve to note the contents of the report of the appendices, approve the proposed changes to the massage and special treatment licensing process, exercise our power under Section 10, Subarticle 1 of the London Local Authorities Act 1991 to prescribe the revised standard conditions for licensed special treatment establishments and the revised special conditions attached with this report. And our motion will also approve the fees and charges for this function as set out in appendices 2 and 3. Is this motion agreed?
Agreed.
We can conclude this item here. Thank you, Ms. Barrett. Are there any new items of urgent business? Then in that case, we can close this meeting here. Thank you, everyone.
Thanks, Jamie.
Thank you.
Thanks, Dale.
Thank you.
Talk to you later.
Thank you. Take care. Bye bye.
Hannah,
Yes.
are you seeing Zena